Hi, everyone. So we're going to be starting the live Q&A now. So Jasmine and Emma, if you can please introduce yourselves.
Hi, my name's Jasmine. I work in the Milton Keynes office. I've done family law for 10 years and I've been at Duncan Lewis for about 2.5 years.
Hi, I'm Emma. I'm a trainee solicitor here in the Milton Keynes office, and I've been doing my training contract for about 6 months now.
Great. So now Emma and Jasmine will be answering some commonly asked questions regarding care proceedings and interim care orders. If anyone has any specific questions that they would like them to answer, please leave them in the chat box and we will answer them as they come through.
Okay, do you want me to start with the first question?
Yes.
Okay, so firstly, what is a interim care order? And essentially, it's a short-term order that gives the local authority parental responsibility for the children. It doesn't mean that the parents lose their parental responsibility. It means that it's shared. The order can be made with the children at home, or an order for removal can also be made with the interim care order, which means that the child would then be accommodated by the local authority for the duration of that order or until further order.
So the next question is, when would a child be removed from their parents? So this question is a bit more difficult because the threshold for this is very high. The court basically must be satisfied that the child's at an imminent risk or significant risk of harm, and that removal is kind of necessary to keep that child safe.
So moving on to what happens in the care proceedings, and really the aim of those proceedings is to find a safe and permanent placement for that child for the rest of their childhood. The objective is to make sure that the child remains with the family where safe to do so. This can be with family, or it can be with family friends, pending assessments. The aim is to keep the child within the family. It's only if that is not a safe option that other options would be looked at.
Yeah. So the next question is kind of a bit similar in the sense of what can the local authority do if they have a care order? And if they have an interim care order, it basically means that the local authority share PR for the child. And this means that they can make decisions kind of about things like where they live, and any issues about welfare of the child.
Yeah. In terms of how long those types of proceedings last, they should not exceed 26 weeks. That timetable can be extended if it is considered to be in the best interest of justice. So normally, if we need further assessments, then the court can consider that it's necessary to extend that timetable to achieve justice for the child and the family.
Yeah. So the next question is to do with kind of the child in the proceedings, and it says, is the party a child to care proceedings? So the short answer is yes. The child will have their own solicitor and they will be represented through kind of a children's guardian. This is someone from CAFCAS who then reports back to the solicitor. Do you kind of want to go into what a children's guardian is?
Yeah, so that moves us nicely onto what a children's guardian is. And their role is essentially the eyes and ears of the court. They are independent, and they are very experienced social workers that work with a entity called CAFCAS. They advise the court on what's in the best interest of the child. They do obtain the child's wishes and feelings so far as possible, but that's only part of their role. They'll also give their professional judgment on what's on or in the child's best interests.
Yeah. So the next question that we have on here is, can an interim order be made whilst the child remains in the parent's care? And they can remain in your care. It just depends on what the court obviously deems to be right at that time. But the simple answer is yes, they can remain in your care whilst an interim care order is on.
Absolutely. Which moves us on nicely to what happens if your child goes into care and who they could be placed with. essentially, if it's not deemed safe for the child to remain in the family, or if assessments need to take place of family or friends, then a child would go into foster care. And foster carers are people who offer a child a safe and nurturing home whilst they're unable to stay with their parents. But those people are regulated by either the local authority or by foster carer companies. And they go through lots of training, and you can get specialist foster carers that can deal with children who have got significant trauma or additional needs.
Yeah. I think this is actually quite a good question, because this is a one, that a lot of people ask, and it's, do I need to pay for my legal fees? As a parent or a child in these proceedings, you're automatically eligible for funding due to the nature of the proceedings. And if you reach out to a law firm, then they can kind of help you with getting that funding.
Yeah, as long as they offer legal aid, that's absolutely fine. It is absolutely right that you're automatically eligible. Just about how much you earn due to the nature of the proceedings, that funding is there for you as the parent or the child, or anyone with PR, I believe.
Yeah.
So moving on to spending time with your child whilst they are subject to an interim care order. When a child is looked after by the local authority does have a duty under law to arrange and facilitate reasonable contact between a child and their parents, as well as siblings, and also any important people in that child's life, including other family members such as grandparents. The local authority's proposal for interim contact throughout the proceedings, pending assessments, etc., will be set out in their interim care plan, which is a document that you should receive from the outset of their application, and then the court will endorse that plan, and which, as I say, will set out as and when that contact will take place.
Yeah. I think we've already kind of answered this one before, but is parental responsibility taken away from the parents in an interim care order? So it's not taken away from the parents. It does mean that the parental responsibility is shared between the parents and the local authority. And the only kind of difference is that the local authority can at any point choose to then exercise their parental responsibility if they consider it necessary.
Yeah, absolutely.
So sorry to interrupt. I think someone has put a few questions in the chat.
Yeah.
Are you not sure you can see
to, let me try scroll up. Sorry, we're just having a bit of.
do you want me to read them out for you?
Yes,
yeah,
please. That would be great. Thank you.
So the first one is, what is the youngest age you can be represented?
from birth.
The second question is, why do solicitors not like to do appeal?
Oh no, you go for it.
No, I don't think it's that solicitors don't like to do appeals. Appeals are complicated, and in order to advise and progress with it, you need to have a barrister's advice on whether that appeal is successful, because you can't just appeal a decision because you don't like it. There is a criteria for what you can and you can't appeal, and the best person to provide that advice would be a barrister. And really, without positive prospective appeal from a barrister, it's unlikely that you're going to be advised that an appeal would be successful, and you'd be advised against it by a solicitor.
Great, thank you. So the next one is there a minimum contact for parents?
No, essentially not. It's down to the court.
Well, I mean, the amount of contact that is going to be recommended by the local authority is going to be case by case dependent. It depends on the age of the child, your relationship with the child, what are the safeguarding risks for that. So, for example, if you have a newborn baby, they tend to have much more contact per week as opposed to an older child, where it may be only once a week. Normally, I think you're probably looking at once a week, maybe twice a week, and with the younger tiny babies, sort of three to four times a week.
Mm-hmm. And then The next one is, what is a normal contact for parents of a 7-year-old?
Again, I think that's a case by case thing. I don't really think there's a standard as far as I'm aware. It would be for the local authority to assess that in terms of their resources as well, and what their contact centres can facilitate. The child's own wishes thing, I don't really think there's a standard as far as I'm aware. It would be for the local authority to assess that in terms of their resources as well, and what their contact centres can facilitate. The child's own wishes and feelings as well. I don't really think that it's easy to suggest what the standard would be. I think in most cases that I've seen, it's sort of once a week.
Yeah, that makes sense. And then I think this is the last one. It says, the judge told me I have zero parental responsibility, that I've lost it.
I don't think that's easy to answer without having the full facts of the case consisted of.
Yeah. So I think if you want further advice, or if you have any more questions, I'm going to leave Emma and Jasmine's email in the comment, in the chat box. So if you have any more questions, please feel free to email them and they can answer those for you.
Yeah. It's sometimes easier when we have like the facts of the case, then we can kind of assess it and then give you more information on your specific factors.
Yes, so I'll just leave that in the chat box right now, and then we can move on with the rest of the questions.
Thank you. I think we've only got one left actually. And it's essentially, can you appeal interim care orders? So the short answer is yes, you can. But to appeal an interim care order, you have to feel that something was incorrect, that the judge got the facts of the case wrong. It's not necessarily, like Jazz said earlier, it's not necessarily you don't like the judgment that came out of it. It's got to be that something was incorrect.
Yeah. Again, that's something that is best to seek advice on from a barrister, for them to consider the facts of the case in order to be able to give you substantive and informative advice about whether an appeal is possible or not. Because you can't, as I say, you can't just appeal a decision that you don't like. There's a criteria for that.
Great, thank you. So I don't think we have any more questions. So I've left, again, Jasmine and Emma's emails in the chat box. So if anyone needs any further advice or help from our family law team, then please feel free to email them. But if we're not getting any more questions, I think that's it for our live Q&A today.